Reporter is here.
Good morning, Ms. Diaz. Thank you for reporting in.
Thank you.
We're going to wait just a minute and make sure everybody gets hooked up here. Looks like we have 28 participants this morning. Okay, I'm going to go ahead and get started. My name is Alan Lilly, presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. This is the second day of the AHO's hearings in the matter of the draft cease and desist order that the State Water Board's prosecution team has issued against BlueTriton Brands, Inc. We're not going to go ahead. I won't repeat appearances this morning. It looks like all the same people who appeared yesterday are here today. So we're just going to get started. I do have a couple of preliminary matters. First, I have another meeting that I have to attend starting at 4 o'clock today. So I'm going to terminate the proceedings at approximately 3:30. If we need to go a few minutes after 3:30, that's fine, but I can't go much later than that. And we'll see where we are. We had talked about having a break anyway to allow time for additional preparations, but we'll see where we are. And the other thing, a matter of housekeeping for you, Mr. Petrozelli, since Ms. Stork has testified, I recommend that you get her a copy of her statement of qualifications and submit that as an additional PT exhibit. And when you've done that, if you can just follow your normal procedure and our normal procedure and upload that to your folder, then we'll move it over to the prosecution team's exhibit folder for this matter. And I will just ask Ms. Stork to authenticate that. But she has testified as an expert witness, so having her statement of qualifications in the record would be desirable. Can you do that sometime today?
I can check with her to make sure she has a statement of qualifications that, ready to submit. If she has one that's ready to submit, we should be able to have it done today, depending on how long the witnesses are testifying. Yeah.
Okay. Well, maybe you can, if possible, do it during the noon break. But as soon as we can, I just think it'd be good to have that in the record. The other thing I wanted to advise everyone is my staff, my wonderful staff, in addition to everything else they've been doing to keep this hearing going, posted the Zoom generated transcripts from yesterday's hearings into the hearing documents folder, which is in the our AHO FTP folder for this matter. Those are the informal Zoom generated transcripts. They haven't been reviewed and they certainly have some errors, but still they can be useful for people to refer to because the times in them, the hours, minutes, and seconds track the time in the Zoom recording, so they can be useful for locating particular passages. As I said yesterday, the video plus audio Zoom recording remains our official record, but the Zoom generated transcripts may be helpful to the parties. So I just wanted to let you know we have posted those. I don't have any other preliminary matters. Unless anybody has something urgent, we'll get started. It looks like Ms. Miller has her electronic hand up. Ms. Miller, please go ahead.
Hi, Mr. Lilly. I just wanted to enter my appearance for CDFW. I did not appear yesterday. Kathleen Miller.
All right. And I don't see Ms. Murray. Is she here today, or are you the only attorney for CDFW today?
Yes, Ms. Murray is not appearing today.
All right. Well, I'm sure she handed the baton to you at some point. So welcome to our hearing and thank you for letting me know. All right. Anything else for this morning? Then let's go ahead and get started. Where we are is at this point, we're ready for BlueTriton's attorney. I'm not sure which attorney that will be, but one of BlueTriton's attorneys to conduct the cross-examination of Tomas Eggers, who testified on direct for the prosecution team yesterday. So you may proceed.
Good morning, Mr.
Mr. Lilly, just a question. Yeah.
Okay.
Before we start, again, the hearing notice allocated, 45 minutes for a panel or 45 minutes per witness. Yesterday, BlueTriton spent well over, I think it was 2.5 hours, just cross-examining mainly Mr. Vasquez. So perhaps we could set some at least preliminary time limits for this morning.
All right. And Mr. Lowe, your hand is up.
Yes, I wanted to say that a big part of the wasted time yesterday was because we didn't interview them or cross them as a team. It's very important that from the very beginning today, if we can, we consider them a team, because it wastes a lot of time saying, oh, well, somebody else needs to answer that. Let's just do it as a team if we can, and let the team decide who's going to answer the questions, because we need to be efficient. We're not being efficient. Thank you.
All right. Thank you, Mr. Lowe. Thank you, Mr. Petrozelli. Regarding Mr. Lowe's, and please take your electronic hand down, Mr. Lowe, if you can. Thank you. Regarding Mr. Lowe's comment first, we do have a panel. I am giving the cross-examining attorney the right to decide whom to ask a question of, and then they can go forward. But of course, each witness is free to say, I don't have any significant or detailed information in response to that question, but the other person on my panel does, and I recommend or suggest you ask that person your question. That's the way we are doing this, rather than just having people sort of a free-for-all where different witnesses on the panel answer each question. It's probably a little less efficient, but I think it's orderly, and I do think the cross-examining attorney has the right, at least in the first instance, to decide to whom he or she wants to direct his or her questions. So we're going to do that. Regarding Mr. Petrozelli's comment, as I mentioned yesterday, the hearing notice did set nominal time limits, although it clearly stated that the hearing officer had discretion to allow more time for good cause. I concluded yesterday that Mr. Sanders' questions, primarily of Mr. Vasquez, were being productive, and I did not want to deny BlueTriton's right to cross-examine by cutting that off. So that's why I allowed that to go forward. But Mr. Petrozelli's point is well taken, that we need to try to keep these proceedings moving forward efficiently and promptly. So I do call on all attorneys, BlueTriton's attorneys this morning, but all attorneys to really think about what questions are necessary for cross-examination, and to limit it to the necessary questions so we can keep moving forward. So having said that, it's going to be 9:10 in 1 minute, and I'm going to allocate 45 minutes to BlueTriton's attorneys as an initial block of time for the cross-examination of Mr. Eggers. And if the attorney still has more questions after that, I'll ask for an offer of proof. So that'll be approximately 9:55 will be 45 minutes. So with that, I assume it's you, Ms. McGuire, you may proceed.
Thank you, Mr. Lilly. Good morning, Mr. Eggers. My name is Rita McGuire. I'm with the law firm of Rita P. McGuire, attorney at law, and I'm here today representing BlueTriton Brands, Inc. Mr. Eggers, my questions are designed to elicit a yes or no response from you. And if you follow that convention, I believe we can finish in less than an hour. But if your testimony is different or extensive, we may need more time. I hope that's not the case. But as you know, your testimony, your written submitted testimony, is significantly different from Mr. Vasquez's. And so there are a number of different issues, unique issues to your testimony, and I will want to question you about those issues. Also, as a result of doing this via remote, I may ask for a short break to consult with my colleagues before I complete your cross-examination. And so with that, let's kick it off. First, I want to get a clarification of the record. Yesterday, when Mr. Vasquez was testifying, he was having difficulty locating Coldwater Canyon on a map in his presentation. And you interjected that Coldwater Canyon was east of Strawberry Canyon. Is that your testimony this morning?
And excuse me, Ms. McGuire, it's a perfectly reasonable question. And to facilitate his answering of it, it's going to help me and everyone else if we put a map up. So I'm going to ask Ms. Mullen to post PT 12, page 2, which were the slides of Mr. Egger's testimony. I think that will help him be able to pinpoint on the map where Coldwater Canyon is. It certainly will help me.
Thank you. And it's actually page 5 on PT 12.
Oh, okay, page 2 is the map. Page 5 is the, looks like a Google Earth photo. So we can go to page 5 if you prefer that. It has better marking, so page 5 is fine. Okay, we now have PT 12, page 5 on the screen. Please proceed, Ms. McGuire. Repeat your question. Restate it if you need to.
Mr. Eggers, it looks like you're prepared to respond.
Yes, Coldwater Canyon would be the canyon through which Coldwater Creek flows, and that would be the middle canyon of those 3 arrows.
And Mr. Eggers, I don't know what it is, but we're having trouble hearing you. Maybe move your microphone a little closer or speak a little louder, or I don't know if you can turn up the volume on your computer, but we want to be able to hear you.
I'll see if I can adjust these settings here.
That's better already.
Mr. Eggers, would you indicate whether Coldwater Canyon is to the east or the west of Strawberry Canyon?
If I said it was to the east of Strawberry Canyon, that was a mistake. It is east of Hot Spring Canyon, west of Strawberry Canyon.
Thank you. All right, if we could go to figure 8 in this same PT 12.
Okay, we'll go to page 8.
I'm sorry, go up 1 then, I think. No, keep going, please, up. I saw it, there it is. Sorry, PT 6 or page 6.
Just for the record, we have page 6 of PT 12 on the screen now.
Mr. Eggers, did you prepare figure 8?
No.
Can you take a look at this figure and look at the 3 arrows at the bottom of figure 8? See those 3 arrows pointing downward?
I see 3 red arrows at the bottom of the figure.
And the middle arrow is pointing to what?
It says it is labeled to bottling plant.
Do you agree that the arrow appears to be indicating that the bottling plant is south of the hotel and also east?
This is a diagram. It's not to scale, and it's just meant to show the basics of the Del Rosa judgment. I wouldn't take anything from the particular positions of these arrows.
Would you agree that the old Arrowhead factory, the bottling plant that's being pointed to, is actually to the west of the hotel and north of Strawberry Creek?
As I said, I don't believe that the arrows are pointing to a particular place there. It's a diagram, a symbolic representation of what was agreed to by the parties to the Del Rosa judgment.
Do you know who prepared this map?
It was prepared by Natalie Stork.
Okay, thank you. Could we please bring up Thomas Eggers' testimony, which is PT Exhibit 10?
Okay, we will do that. And what page would you like us to go to?
I'd like you to go to page 2, lines 8 and 9. Mr. Eggers, according to your testimony, you began working on the Nestle, now BTB complaint in January of 28, and I quote, "in preparation for the departure of Natalie Stork from the Division of Water Rights," end quote. Is that correct?
No, it was 2018, not 28.
2018. So your testimony is that you began working on the Nestle complaint in January 2018 in preparation for the departure of Natalie Stork from the Division of Water Rights?
That's correct.
And that was immediately after the Division of Water Rights issued its December 2017 report of investigation, correct?
It was after the ROI was issued.
Okay. Can you tell me why Victor Vasquez's written testimony states that he did not assign you to the Nestle Water Rights investigation until March of 2018?
No, I can't explain why that's. We started working in preparation for Natalie's departure. So I'm not sure about the official date. I don't think there's an official date for that assignment that I can recall.
Okay, so your January 2018 was just a guess?
No, I had conversations with Natalie around that time. It was clear that I would take over the case after she left. We knew that she was leaving.
When did she leave the Division of Water Rights?
I don't know.
Would you disagree with me that Victor Vasquez's testimony says she left in October of 2017? And if you like, it can pull up his testimony.
Objection, hearsay, the testimony says what it says. She's asking him to say what the testimony says.
Well, I'm going to overrule that objection on the grounds that Mr. Vasquez did testify in this hearing to this yesterday. But Mr. McGuire, I don't know that this is really necessary. I mean, his testimony says whatever it says, and I don't think anybody's disputing that. So what is your specific question for Mr. Eggers?
My specific question was with respect to the departure of Ms. Stork. She actually left in October of 2017, and yet his testimony is that he began working in January in preparation for her departure. And in fact, there was no overlap in the time in which he joined the role as lead investigator in Ms. Stork's departure.
So what is your question for Mr. Eggers?
I was asking him whether or not he agreed that Natalie Stork left in October of 2017.
All right, Mr. Eggers, if you know, you may answer, and if you don't, you may say you don't know. And incidentally, if we want clarification on this, I'll state the obvious, we can ask Ms. Stork. But anyway, go ahead, Mr. Eggers. If you know, answer, and if you don't, say you don't know.
I think I would refer this question to Ms. Stork.
Is Ms. Stork available?
Yes, I'm here.
Okay.
All right, so Ms. McGuire, we are a little flexible here with our panel questioning. If you want to shift over to question Ms. Stork about this point and then go back to Mr. Eggers, that certainly is fine.
And I'll point out that Mr. Vasquez has his hand up as well.
All right, well, yeah, this is a little tricky, but I think Mr. Petrozelli, we're not going to allow Mr. Vasquez to butt in here unless somebody asks him a question. But you should make a note of that. If you think there's something on this point that he wants to cover, you can cover that on redirect. So with that, Ms. McGuire, please proceed.
I'll move on. Mr. Eggers, let's go to paragraph 3, which is on the screen at the bottom here. Is it your testimony that you were assigned to lead the investigation of Nestle's, now BTB's, water rights in Strawberry Canyon?
What line is that on?
It's on line 8.
Yes, that's what I testified to.
Did you have any involvement with the preparation of the 2017 ROI prior to its publication in December 2017?
Define involvement.
Define it in helping to draft it, to do any research, to develop any data related to the contents of the 2017 ROI?
Drafting, research, or developing data? No.
Thank you. Did you attend the site tour in Strawberry Canyon on June 15, 2016?
I did not.
Mr. Eggers, both your written and your oral testimony contain a number of legal conclusions. Are those your conclusions?
And I'm going to interpose an objection to that. I think that's an overly broad question. I think, Ms. McGuire, if you want to ask him about specific legal conclusions, I think that's fine. But I think it's an improper and overly broad question to ask generically about a declaration that's 24 pages long.
Okay, thank you. Did you prepare your written and oral testimony, Mr. Eggers?
Yes.
Were you assisted with your preparation by either Mr. Vasquez or Ms. Stork?
Yes.
And were you assisted by either Mr. Petruzzelli or Mr. Prager?
Yes.
Are you a lawyer?
No.
Okay. And you're not presented here today to testify as a legal expert in this proceeding, are you?
No.
In fact, you're an environmental engineer with an undergrad and graduate degrees in environmental engineering, correct?
That's correct.
Let's see, we still have your testimony on the screen. Could you read paragraph 4? We'll need to scroll up just a bit here. Lines 15 through 17.
My role in this enforcement action was to analyze information submitted in response to the 2017 ROI, revise the ROI as appropriate based on any new and relevant information received, and draft responses to comments that did not result in changes to the 2017 ROI.
Thank you. Can we conclude from that statement that you have a thorough knowledge of the conclusions reached in the 2017 and 2021 ROIs?
You can conclude that.
Okay, thank you.
Sorry, Mr. Eggers, you broke up a little bit. Could you please just repeat that answer? I couldn't quite hear it.
Yes, that's a yes.
Can we go to exhibit PT-4, please?
All right. We'll get PT4 and put it on the screen.
Good, thank you.
All right, PT4 is on the screen. Please let us know what page you'd like us to scroll to.
Let's just stay on this first page for a moment. Mr. Eggers, are you familiar with the response to public comments that is on the screen?
I'm familiar with it.
Did you draft these responses in whole or in part?
Yes.
Thank you. Can we go to page 2, paragraph 4? Actually, before we do that, if we could just stop here. Mr. Eggers, what is the date of this document?
It says January 30th, 2020.
Thank you. Do you know when that document was made available to the public?
I believe it was made available with the CDO and the 2021 ROI.
To your knowledge, do you know whether or not BTB was ever notified of the completion of the response to comments in January of 2020?
I don't believe so.
Thank you. Now let's go to page 5. And I think we need to go to the bottom of page 5. It should be response number 2.1.2. Here it comes.
Okay.
Could you read, let's see here. The very last paragraph starting additionally.
Additionally, the revised ROI recommends that Nestle immediately cease all diversions of water that is within the SWRCB's permitting authority in excess of a combined 7.26 acre-feet annually from all extraction facilities in Strawberry Canyon.
I think that's fine. Thank you. So is it fair to say that as of January 2020, the state Water Rights Division, the Water Rights Division in the State Water Resources Control Board had reached the conclusion that BTB's right to divert water that's at issue in this proceeding was limited to 7.26 acre feet annually.
And Ms. McGuire, again, I have to clarify, I want to make sure our record is clear on this. The Division of Water Rights has different sections. And as I said stated in my letter to Mr. Donlin on Friday, part of the Division of Water Rights is in the hearing team and part is in the prosecution team, which is a little bit confusing. That's why I submitted the organization charts with the letter. But I think it's best if you restate your question in terms of Division of Water Rights enforcement section. So if you don't mind just restating it that way, I know you weren't intending to be confusing here, but that will just make our record clearer. So if you can do that, I would appreciate it.
Okay, thank you, Mr. Lilly. Mr. Eggers, is it correct to say that as of January 30th, 2020, the Water Rights Division enforcement section had reached the conclusion that the water rights at issue in this hearing belong to BTB were limited to 7.26 acre feet annually?
I might not say it that way.
How would you say it?
That the evidence pointed that direction.
Did you prepare the response to comments?
I did.
And is that an affirmative statement? That a recommendation is being made that Nestle immediately cease and desist all diversions of water that is within the State Water Resources Control Board's permitting authority is in excess of a combined 7.26 acre feet annually?
Well, yeah, I think at that time that the evidence was pointing that direction, but until the report is issued, anything could change.
Did this report change at any point between January 30th, 2020 and April 23rd?
Could you clarify which report?
This report that's on the screen, Mr. Eggers.
And just to clarify, when Ms. McGuire says this report Ms. McGuire, are you specifically referring to this exhibit, the response to comments?
I am.
Okay, just to distinguish it from the report of investigation issued in.
Yeah, I'm going to sustain that. It was sort of an objection, but treat it as an objection and sustain it. So Ms. McGuire, why don't you just restate your question in terms of this document? I think that would make the point clearer.
Mr. Eggers, I was asking you whether or not this report of responses to comments dated January 30th, 2020, that's up on the screen before you, and specifically the paragraph at the bottom of page 5, concludes that Nestle is to immediately cease all diversions of water that is within the State Water Resources Control Board's permitting authority in excess of a combined 7.26 acre feet annually from all extraction facilities in Strawberry Canyon.
I would say that, yes, that's what this document says.
Okay, thank you. Do you agree that this response to comments was published 15 months prior to the publication of the revised report of investigation on April 23rd, 2021?
And again,
Can Ms. McGuire specify as to what she means by published?
Yeah, Ms. McGuire, I don't know that this was intentional, but published sort of implies a public distribution, and he's already testified it was not publicly distributed until 2021. So I think some word other than published would probably be better here.
My question maybe is even more simple than that. I want to ask Mr. Eggers if he can explain why there was a 15-month delay between the completion of the January 30, 2020 response to comments and the ultimate issuance of the April 23rd, 2021 report of investigation.
All right, so Mr. Eggers, you may respond to that question.
Oh, was that a question? Okay.
Yeah, let me just say it. Why was there a 15-month delay between the completion of this document in January 2020 and the completion of the ROI draft CDO and release to the public and to BlueTriton in April of 2021?
There was a lot happening between those times. I'm not sure I can isolate a particular cause.
Okay, thank you. Mr. Eggers, as the lead investigator of Nestle, now BTB's water rights, were there any substantive changes made to the revised ROI during that 15-month period that you're aware of?
I guess it depends on what you mean by substantive, but I don't recall.
Okay, thank you. Can we pull up PT exhibit number 3?
Okay, PT3 we will post on the screen. It's a big file, so it'll take us just a moment.
And ultimately, I'd like to go to footnotes 22 through 34.
Okay, it'd be good if you have the page number. That'll help for our locating it.
Okay, let me first ask Mr. Eggers, do you recognize this document?
I believe so.
Did you have some involvement in the preparation and ultimate publication of that document?
Yes.
Okay, thank you. Footnote 22 begins on page 20 of this exhibit.
All right, we'll go to page 20 and see where we are. Sometimes the page numbering is a little off, but we'll go to page 20 and see whether the footnote is on that page. And again, please be patient. It's a big file, so it takes a moment for it to scroll down. There we go. Okay, so we now have we'll go down to the bottom and make sure it's page 20. Click one, there we go. Okay, so this is page 20.
Thank you. Mr. Eggers, take your time. Please look at these footnotes. I'm focused on 22 through 27. So all of the footnotes on the bottom of page 20.
Okay.
All right, thank you. With the exception of footnote 26 here, would you agree that these footnotes cite as the source Doty comment? I believe that's in footnotes 22 through 25. And then 27 cites Amanda Fry, exhibit A30.
That's what it says.
Do you know the date of the submission of the Doty comment to the Division of Water Rights? There's no citation here.
I would have to check the exact date. I don't recall.
Do you know the date of the submission of the Amanda Fry exhibit A30?
Well, Amanda Fry had several submissions, and a lot of them were repeat. So that A30 may have been in 2017, or it may have been her other submission that she did later when she resubmitted a Dropbox submission, which would have been.
And again, just so our record is clear, Mr. Eggers, by submission, I assume you mean submission to the Division of Water Rights Enforcement Section. Is that correct?
That's correct, yeah.
All right. Please proceed, Ms. McGuire.
Do you happen to know, Mr. Eggers, how Amanda Fry's exhibit was submitted to the Water Rights Division? Sounds like you may have answered that, but I'm going to go ahead and ask you because it's not posted on the prosecution's exhibit list.
She submitted by email, and by a Dropbox link that contained files.
Okay, thank you. Could we go to PT number 10?
All right. PT 10, this is back to the written testimony of Mr. Eggers.
Correct.
And what page would you like to go?
I'd like to go to page 2, lines 24 through 26.
All right, we're there.
Okay, could you read the sentence that begins on line 24, starting with only?
Only comments and new information received through August 2018 were included in the revised report of investigation.
Thank you. Let's see. Can you tell me when the Water Rights Division decided to extend the public comment period from February 9, 2018 to August 2018? And what was the basis for that decision?
And again, Ms. McGuire, I just want to caution you because it's so important. It's Water Rights Division Enforcement Section is your question.
Okay, thank you.
But with that, go ahead, and if you can answer, Mr. Eggers, go ahead.
Can you show me in my testimony where I say that?
Only?
Well, that doesn't say that.
No, it says that only public comments and new information received through August 2018 were considered in the revised report of investigation. Is that
It
correct?
doesn't say
Objection, that
that.
mischaracterizes the testimony. It says included. And
Yeah.
to properly characterize this testimony, it's important to read it in the context of the entire paragraph.
Mhm.
All right, the objection is sustained. Ms. McGuire, and I'm going to say I ruled yesterday that the prosecution team, that there was no legal requirement that they limit the draft CDO to comments received. I think that then we were talking about February of 2018, but I certainly I believe my ruling was that they had the discretion or the authority to submit exhibits that they received after that date. So I'm not sure where you're going with this whole line of questioning. As I said yesterday, the Water Rights Enforcement Section and the prosecution team are not subject to any due process procedural requirements regarding BlueTriton. I think they can pretty much conduct their investigation any way they want. Now, obviously, as long as they comply with all applicable laws. But as far as these dates go, I just really don't know that any of this matters. So maybe you can explain to me why you were pursuing this line of questioning.
Thank you, Mr. Lilly. I will. I think in the next few questions, it'll become apparent.
All right, well, why don't you go ahead and ask the questions, and please do try carefully to refer to Division of Water Rights Enforcement Section. And then if you're asking specific questions to Mr. Eggers, do point to the specific testimony you want to ask him about.
Okay. I have one last question about the sentence that begins on line 24. Is it correct to say that the statement, only comments and new information received through August 2018 were included in the revised report of investigation, is incorrect?
I'm sorry, it's just a little confusing. It's a double negative the way you've asked it. I'm going to restate the question here. Mr. Eggers, is the statement on lines 24 through 26, which reads, only comments and new information received through August 2018 were included in the revised report of investigation. Is that statement correct or incorrect?
That's correct in general, yes.
All right, Ms. McGuire, you may proceed.
Mr. Eggers, will you agree that Nestle's final report due on June 20th, 2019, and based on the 2017 ROI's direction was submitted to the division after August 2018?
Yes, we received something from Nestle at the time in 2019. That's correct.
Does your statement in this document up on the screen, starting on line 24, does that statement mean that the final report submitted by Nestle was not considered by the Division of Water Rights Enforcement section?
The revised report of investigation included any significant changes to the report. And I don't believe anything in the 2019 submittal significantly changed the revised report of investigation. That's not to say that it wasn't considered.
Okay, thank you.
I'm objecting to the extent this mischaracterizes the witness's testimony by putting it out of context. Read in the context of the entire paragraph, it is clearly in the context of the comments that were requested of the public. You know, the paragraph explains that.
Mr. Petrozelli, stop. I think we've belabored this enough. I'm going to overrule the objection. If you believe that you need to have Mr. Eggers clarify this point, please make a note now, and you can ask him to clarify this point on redirect. That'll be far more efficient than addressing this point through objections. So, Ms. McGuire, you may proceed.
Thank you, Mr. Lilly. Pull up exhibit BTB number 5.
All right, BTB 5 we will get. Okay, I believe we have BTB 5 on the screen now. Yeah, Ms. McGuire, you may proceed.
Yes, thank you. Mr. Eggers, do you recognize this document to be a submission by BlueTriton Brands to the Division of Water Rights Enforcement section on June 20, 2019?
Yes.
And was that this report dated June 20th, 2019, provided at the request of the Division of Water Rights Enforcement staff pursuant to its 2017 report of investigation?
I believe so.
And would you also agree that the 2017 ROI's transmittal letter, and I'm happy to have that pulled up if you like, but described this fourth and final report as a compliance plan?
Could you pull that up?
Yes, please. It's PT number 14.
All right, we will get PT 14. All right, we have PT 14. What page would you like us to go to on this?
The bottom of page 3, please.
All right.
This final,
Correct.
Thank you, Mr. Lilly. Mr. Eggers, could you please read the final bullet? You only need to read the bullet, or you can stop wherever you like.
Number 4, include a compliance plan.
Okay, fine. So you would agree that the fourth and final report provided by Nestle to the Water Rights Division Enforcement section was in fact a compliance plan at the direction of the enforcement section?
Objection. Can Ms. McGuire be clear as to whether or not it was a compliance plan consistent with one that was requested by the division?
I think we can cut through this. I'm going to just ask the question, Mr. Eggers. Mr. Eggers, was the letter that Ms. McGuire submitted to the Division of Water Rights Enforcement section on June 20th, 2019, which is exhibit BTB 5, was that the document that BlueTriton Brands submitted in response to the directive in this fourth bullet on the bottom of page 3 of this exhibit.
If we could bring up that submittal, and if I recall, they claim that that's what it is in the submittal.
All right, I think that's probably sufficient. Ms. McGuire, do you need to follow up? If you want to ask him any follow-up questions about the submittal, we'll post it on the screen, but otherwise, I think we can move on.
Yes, I think we can too, Mr. Lilly.
Right.
I'm going to move on to the third response submitted to the Water Rights Enforcement Section, the Water Rights Division Enforcement Section on April 10th, 2018, which is BTB Exhibit 4.
Okay, do you want us to put up BTB4?
No, we don't have to, but I just simply want to make sure that Mr. Eggers has the documents he needed to respond. My question is going to be whether or not this third response submitted by Nestle back in April of 2018 was considered by the enforcement staff in the preparation of the 2021 ROI.
All right, Mr. Eggers, if you can answer that question without posting the exhibit, we won't post it. If you want us to post it, we will.
Could you post the exhibit?
All right, so Ms. Mullen, please post exhibit BTB4. All right, we have BTB4 on the screen. Ms. McGuire, please, if you need to please restate or repeat your question so Mr. Eggers can answer now that he has this exhibit in front of him.
My question to Mr. Eggers is whether he knows if this response number 3 requested by the Water Rights Division Enforcement Section was included in the report of investigation. And this question is a little bit different in anticipation of Mr. Petruzzelli's objection. I'd like to know whether or not this report was ever referenced in the 2021 report of investigation. And this is report number 3.
Okay, and just so we're clear, you asked included in, but then you said referenced in. So I'm going to just restate the question. Mr. Eggers, did the 2021 report of investigation reference or refer to this April 10, 2018 letter that is exhibit BTB4?
I would have to look at the evidence more to refresh my memory.
Mm-hmm.
Okay, and Ms. McGuire, you can make your point in closing argument by looking at the 2021 ROI and see whether it refers to this or not. I'm not sure we need to spend a lot of time asking Mr. Eggers that. I think you can make the point if you want to make an argument based on it from the documents in the record.
Thank you, Mr. Lilly. What I'm attempting to do is establish the foundation that, in fact, the 2021 ROI never referenced this second, third, or fourth reports that they requested we submit in that report of investigation.
Okay, and I think you can make that argument in closing brief based on documents in the record. So I don't see any reason to ask Mr. Eggers any more questions about this.
Mr. Eggers, it's also true that you did not post correspondence from Ellison Snyder, Harrison Donlin on behalf of Nestle in April 17, 2020 on the State Water Resources Control Board website, correct?
And again, I just want to make it clear, the question is, Mr. Eggers, did you post this April 2020 letter from Ellison Snyder on the Division of Water Rights Enforcement Section webpage?
Could you bring up that document?
It is PT 112.
All right, give us one moment. We'll get PT 112 up.
Mr. Eggers, do you recall, is this letter from Ellison, Snyder, Harrison, Donlin posted on the State Water Resources Control Board's website with all the other public comments that have been received?
And again, I'm sorry, Ms. McGuire, but because Mr. Donlin has raised the issues of the separation of functions between the prosecution team and the hearing team, it's important that we, including you in this questioning, make that distinction. So when you say the State Water Resources Control Board website, that's confusing because the Administrative Hearings Office has documents that are posted, at least on the FTP page. There are other divisions that post various documents on the website and so forth. So I think your question is, did the Division of Water Rights Enforcement section post this letter from Ellison and Snyder on its website? Is that what you want to ask, Mr. Eggers?
Mr. Lilly, if you say that's the case, all I know is that when you go to the State Water Resources Control Board website and search for Nestle, it pulls up with all of the public comments posted. If that
Okay.
Objection, attorney is testifying, and the AHO, and Mr. Lilly, I believe you made a copy of the enforcement section's webpage with this item. So it's all there if we want to see it.
We included in our administrative record the list of documents from the enforcement section's webpage. We did not post all those documents. And during one of the pre-hearing conferences, Mr. Petroselli asked, it was either a pre-hearing conference or a statement, if we were going to post the links. And I said, no, if anyone wanted to submit those documents as exhibits, they needed to. And clearly the PT has submitted this document as an exhibit. So again, Ms. McGuire, if you want to keep asking these questions about what the prosecution team posted on the State Water Board's website within the PT section, I'm going to allow a few more, but I don't really see the point here of these questions. I mean, that whatever it is, they are now exhibits in our hearing record, and BlueTriton and other parties may make arguments based on them. And exactly what the prosecution team's process was leading up to the draft CDO, I'm not sure that has great relevance to this proceeding.
Thank you, Mr. Lilly. Let me ask a wrap-up question then. So Mr. Eggers, in preparing the 2021 report of investigation, the Division of Water Rights Enforcement section considered some documents obtained from select members of the public, like Ms. Doty and Ms. Fry, but a monitoring and reporting plan as report number 2, an interim compliance plan as report number 3, and a final compliance plan, all submitted by Nestle as report, and that one was report number 4, at the direction of the Division of Water Rights Enforcement section, as well as this letter from Nestle's lawyer explaining in extraordinary technical and legal detail why the division had not properly considered Nestle's groundwater rights in Strawberry Canyon was ignored by the division. Is that correct?
Objection, can Ms. McGuire, there's some compound questions in there. Could Ms. McGuire perhaps simplify or rephrase her question?
I think it certainly is compound, but I think it's clear. Mr. Eggers, if the question is clear to you, please answer it. If it's not clear to you, please tell me it's not clear to you.
Could you repeat the question?
Yes.
Okay, I'm gonna try to cut through this, and maybe it will help. And Ms. McGuire, if you don't think I've stated this properly, you may let me know. But Mr. Eggers, did the prosecution team, as it was developing the 2021 ROI, consider documents submitted by Ms. Fry and Ms. Doty and ignore documents submitted by BlueTriton Brands and its attorneys?
No.
All right. Ms. McGuire, I think that covers it, but you may, if you think there's a follow-up, try to ask short questions that are not compound.
Let's move on to Mr. Eggers' testimony. PT 10, please.
All right, PT 10 we'll put back on the screen.
Thank you. And when we go to page 5, Mr. Eggers, could you read the boldface heading starting on line 10?
Staff relied on fundamental California water rights principles while evaluating the respondent's claims of right.
Do you agree that fundamental California water rights principles includes Water Code sections 1200 and 1201?
The water code is definitely what I would include in the fundamental California water rights principles.
And would you agree that the four-part test described in California Appellate Court decision North Gualala versus State Water Resources Control Board articulates the fundamental California water rights principles?
Objection calls for legal conclusion.
All right, I'm going to
Lack of
overrule.
foundation, fails to ask whether the witness is even familiar with that court decision.
All right. Those are a couple of different objections. I'm going to overrule the objection on the grounds it calls for a legal conclusion. Mr. Eggers has basically opened the door and brought into his testimony some principles of California water rights law. So it is appropriate for Mr. McGuire to ask him questions about those. Now, he is an engineer and not a lawyer, so he can state, this is my understanding, and clearly his understanding is going to be more limited than that of a California lawyer who specializes in this field. So I overrule the objection on that part. I'm going to sustain the objection on the grounds of lack of foundation. I do think, Mr. McGuire, you have to first ask Mr. Eggers if he is familiar with the four-part test from the North Gualala decision before you can ask him a question about it.
Thank you, Mr. Lilly.
I'd further also request an offer of proof as to how this question is specifically relevant to Mr. Eggers' testimony here.
And that is, I'm
His
going to.
testimony is very compartmentalized. It's very.
Mr. Lilly, I object. The prosecution is testifying.
All right, wait, everybody stop. I'm going to overrule that objection, Mr. Petrozelli, under Government Code 11513 subdivision B. It is appropriate on cross-examination for an attorney to ask questions that are relevant to the hearing issues, whether or not they are within the witness's direct testimony. So Ms. McGuire can ask him these questions about the North Gualala test, which I do believe are relevant to the hearing issues in this case. And Mr. Eggers can testify whether he knows about it or not. So with that, Ms. McGuire, please ask Mr. Eggers the appropriate foundational question, and we'll start with that.
Thank you, Mr. Lilly. Mr. Eggers, are you familiar with the case known as North Gualala versus State Water Resources Control Board?
I know it exists.
Are you familiar with the four-part test articulated in that decision, North Gualala versus State Water Resources Control Board?
Would refer questions about the four-part test to Natalie Stork.
Okay, we'll take that up later. Let me go now to Exhibit PT3.
All right, we'll put up PT3.
And can we go to page 8, please?
All right, we have PT3, page 8.
Great, and I'm interested in section 2.1, so we can scroll up a bit.
Yeah, actually, but we'll scroll.
Thank you.
All right, we have that. Please go ahead.
Mr. Eggers, can you please read the introductory sentence, which is the beginning of the second paragraph under section 2.1?
I'm sorry, which paragraph?
The second paragraph beginning diversions of surface water.
Diversions of surface water and groundwater in the Santa Ana River watershed are subject to the regulatory authority of the State Water Board in 6 ways.
Could you read subparagraph 1, please?
Diversions from surface streams and from subterranean streams flowing through known and definite channels are subject, should say, to Division 2 of the Water Code, and thus subject to the permitting authority of the State Water Board, unless diverted under a valid riparian pre-1914 or other valid basis of right.
Mr. Eggers, why wasn't this test used for the determination of Nestle's surface water rights in Strawberry Canyon in the 2021 ROI?
Objection vague. Could Mrs. McGuire please specify what she means by this test?
All right. I'm going to sustain the objection. Ms. McGuire, I think it assumes facts, not in evidence. I think you have to first ask him whether or not the prosecution team considered or applied this test, rather than simply assuming that they did not. So if you can ask the foundational question, I think that will be fairer to the witness and our process.
Thank you, Mr. Lilly. Mr. Eggers, did the Division of Water Rights Enforcement section apply the definition used in subparagraph 1 in determining Nestle's, now BTB's, water rights in Strawberry Canyon?
I think that's a better question for Natalie Stork. This is her section of the report.
Is Ms. Stork a lawyer?
If you know, Mr.
Not that I know of.
Okay, thank you. Let's just go to PT number 1, the draft CDO. Could you go to page 6, please? Mr. Eggers, could you read the first sentence in E at the top of the page?
California law presumes that a spring tributary to a stream is part of the stream and is therefore subject to the dual doctrines of riparian rights and prior appropriation. Gutierrez v. Wedge, 1905, 145, Cal 730, 734.
Mr. Eggers, is it your understanding that this is the test the Division of Water Rights Enforcement section applied when determining the nature of BTB's water rights in Strawberry Canyon?
Objection vague. It's a pretty complex determination. Stream or spring by spring. Question is general.
I'm going to overrule the objection. Mr. Eggers, if you know if the Division of Water Rights Enforcement section applied this test to any of the springs involved in this case, or springs and water sources, you may answer. If the answer varies source by source, then you may say so. So objection is overruled. You may proceed. You may answer the question.
My understanding is that a spring tributary to a stream is part of the stream. I believe that's a correct statement of our understanding.
Okay, thank you, Mr. Eggers. Can we go to PT 10, please? That's Mr. Eggers' testimony.
Right. We're back on PT 10. What page would you like to go to?
I'd like to go to page 11, please, and paragraph 32.
All right. We will go to page 11 and scroll down to 32. Go ahead.
Mr. Eggers, could you please read paragraph 32?
Based on the available information, the 2017 and 2021 ROIs concluded that all the water diverted by AHSHC for use in hotel facilities on hotel property had been diverted under a riparian right rather than appropriated under any of the various notices of appropriation. Consequently, the 2017 and 2021 ROIs concluded the claims in the notices of appropriation were not perfected by actual appropriation and non-riparian beneficial use and cannot be used as the basis for any valid appropriative water right.
Mr. Eggers, would you agree that your testimony in this paragraph 32 is that even though David Noble Smith and his successors filed notices of appropriation since 1887, the prosecution team is now concluding that it was not an appropriation, but a riparian use?
Objection to the extent that mischaracterizes the testimony of the witness. The testimony is written in the written testimony.
Ms. McGuire, I think you have to split that up. I think there's a foundation lacking here because your question includes discussion of David Noble Smith's notice of appropriation, but you hadn't previously asked him about that. So I don't think we have a foundation for that. So I think you need to ask him first a foundational question about that notice of appropriation, and then your question about this paragraph may be appropriate. But I think it's a little confusing to just refer to that notice of appropriation out of the blue without any foundation. So I sustain the objection and ask you to restate the question and proceed that way.
All right, thank you, Mr. Lilly. Mr. Eggers, in the course of the preparation of the 2017 and 2021 report of investigation, did you review the notices of appropriation filed by David Noble Smith for the property known as the Arrowhead Springs Hotel?
Could you bring up those notices, please?
They are footnotes, I believe. It'll take me a second to find those.
And could we get the actual notices that Mr. Eggers requested, not like the footnotes?
Yes, please.
Excuse me. Wait.
That's what I'd like.
Okay, this is what I'm going to do. Mr. Petrozelli, that was sort of an objection, not really, but it was like an objection. I'm going to overrule that. I think Ms. McGuire is entitled to refresh this witness's recollection by referring to the footnotes. But then if Mr. Eggers says, well, that doesn't really refresh my recollection, I need to see the actual notices, then we can get the notices if they're in the record.
That is what I was asking for.
This is going to take a minute. This is a good time for a break. I do want to for a time check. These questions are relevant and on point, and I think you're being efficient. So I don't want to criticize you for that. But we have gone for an hour now, and I would like you to tell us what subjects you intend or want to cover that you have not covered yet, and what your estimated time is to do that.
Mr. Lilly, I would like to spend a few questions talking about these notices of appropriation and the conclusions drawn from them. I then want to talk about the conclusions drawn in Mr. Eggers' testimony, as well as the 2021 report of investigation about the source of bottled water at the Arrowhead Hotel. In addition to that, I want to talk a little bit about the testimony of a Mr. Frank McDonald in the 1910 through 12 litigation between Arrowhead Hot Springs Hotel and Arrowhead Cold Springs Company. All of these items are cited in Mr. Eggers' testimony and of course are discussed in the 2021 report of investigation.
And what is your estimate? I mean, I realize it's hard to know time because there can be objections and so forth, but do you have an approximate time estimate to cover these three topics?
Question for clarification. Does Ms. McGuire mean, I think she said Arrowhead Cold Springs Company. Does she in fact mean Arrowhead Springs Water Company?
Mr. Lilly, if I could respond to that, Mr. Petrozelli is fully aware that there are multiple names to these companies, and for shorthand, I will refer to Arrowhead Hot Springs Hotel, which is a predecessor in interest, to BlueTriton versus Arrowhead Cold Springs Company, which is not a predecessor in interest. And
Okay.
That would be the 1912 case.
All right, so we can cover that, and for my benefit, it's going to be important to make very clear who these different parties are because I'm still learning. I think Mr. Petroselli raises a valid point. We do have to make sure we're clear when you ask the questions, and I have confidence you will be. So what is your estimated time for covering this remainder of this cross-examination?
Mr. Lilly, I believe it'll be about 45 minutes, perhaps a little less, 30 to 45 minutes.
Okay, so this is what we're going to do. It's 10:11. Let's take a break until 10:25. And that will give us you all a chance to locate the exhibits and to have them ready. So I'll tell you what, let's do this. Why don't you, well, I'm not going to do, I was going to say you can come back on the record without my being involved, but I don't want to do that. Let's come back at 10:25, but Ms. McGuire, I do expect you to have citations to all the exhibits ready. And then I'm going to ask you to give those, to tell us all what those are. And sorry, I'm thinking out loud here. How long will it take you to find the citations?
I have the citations that were referenced by Nestle in its original February 9th response to the board or to the Division of Water Rights. It will take me longer to find all of the references in the reports of investigation, and there are numerous ones.
Okay, and what we need are citations to exhibit numbers so we can post them on the screen. So I'm going to give you till 10:25 to prepare a list of the exhibits you want us to post on the screen so that you can ask Mr. Eggers questions about those. And then we'll come back at 10:25 and get that list. And if necessary, we may have to take another break to give Mr. Eggers a chance to review them if they're lengthy documents that he doesn't recall. But let's do that. So please, everybody, do not sign off, but you may turn off your microphone and cameras, and we'll come back at 10:25 and start with Ms. McGuire's list of the exhibits she wants to cross-examine with. Thank you. All right, it's 10:25. We're back. I don't see Mr. Petrozelli yet. I'm going to give him one more minute. There's Mr. Petrozelli. All right. Ms. Grady, you have your hand up, your electronic hand. Do you have a question?
I do. Thank you, Mr. Lilly. I just had one housekeeping issue that I'd like to address. In this proceeding, we've had a lot of pressure to have our testimony or cross-examination, completed in quick amount of time, which I recognize everybody's time is important. But to that end, we asked that maybe you could limit the objections by counsel to limit the speaking objections. And that's for two reasons. One, as the attorneys know, and just for the benefit of those who are not, attorney's argument is not testimony, it's not evidence, and we're able to make any legal arguments about the relevance or any other portion of testimony in our papers. And two, it allows the proceeding to get on with. I think we're spending a substantial amount of time with legal argument on this side that probably could be avoided.
All right, well, I appreciate your comments. It's certainly objections should be limited to the objections, and to the extent people are not doing that, I ask them to do that, and I will continue to try to limit people speaking when they're objecting to just stay in the objection. So I understand your comment. It's sort of a case-by-case matter, but we'll do what we can. So thank you. Ms. Fry, do you have a question? I do want to get moving here, but go ahead.
Yeah, I was just having problems hearing Miss Grady, so I don't know, maybe they corrected the audio.
Yeah, she was a little crackly, but it may have been feedback from someone else's computer. Miss Grady, just try talking again. Let's see whether we can hear you better now.
Right, can you hear me better now?
Yeah, you're still a little crackly. I don't know why there's feedback, but we'll see. But since you're not speaking right now, hopefully it'll eliminate the problem before you are speaking. We all have issues with that. So let's go ahead and get moving forward. So Ms. McGuire, were you able to identify the exhibits that you want to have us post while you're asking Mr. Eggers your next round of questions?
I can, Mr. Lilly, but in the interest of time, I'm going to drop this current line of questioning. I don't think that it's going to be the best use of our time, and I'd like to move on to a new subject area.
All right. So what is the new subject area you're going to move on to? I had notices of appropriation. Is the next area you want to go on to the conclusions about sources of water?
Yes.
All right. So please proceed. And as I said, as much for my benefit as anyone else's, please very carefully distinguish between these various historic entities, particularly the Hot Springs Hotel and the Cold Springs and so forth, because obviously that's very important. And I want to make sure I get it all right. So please proceed.
Thank you. If we could, please pull up exhibit number 39.
Is this PT 39?
Yes, PT 39, a report by the San Buenaventura Research Associates.
All right, we will get PT 39. All right, we have PT 39. What page would you like to go to? Or do you want to start on page 1? Go ahead.
Yes, please. Mr. Eggers, could you please read the title of this document? You're on mute.
Yeah, go off mute, Mr. Eggers.
Thank you.
We all do that. Please go ahead.
Historic Resources Report, Arrowhead Springs Hotel, San Bernardino, California.
And who was this report prepared for?
I believe it says the Planning Center.
Thank you. And am I correct that this report is identified as an administrative draft?
I believe it says that.
Okay, thank you. Let's go to page 2. Under the heading Introduction at the top of the page, would you please read the full paragraph immediately under the heading?
This report was prepared for the purpose of assisting the city of San Bernardino in their compliance with the California Environmental Quality Act, CEQA, as it relates to historic resources in connection with the city's consideration of the proposed Arrowhead Springs specific plan, Figure 1.
Thank you. You don't need to read the list, but the following paragraph, I would appreciate if you would read it.
This report assesses the historical and architectural significance of potentially significant historic properties in accordance with the National Register of Historic Places, NRHP, and the California Register of Historical Resources, CRHR. A determination will be made as to whether adverse environmental impacts on historical resources as defined by CEQA and the CEQA guidelines may occur as a consequence of the proposed project and the adoption of mitigation measures as appropriate.
Thank you. Did you review this report in the preparation of the 2021 report of investigation?
Yes, I reviewed this document.
Thank you. Could we go back to the 2021 report of investigation, which is exhibit PT number 3?
Okay, we have PT3.
Page 35, please.
We will go to page 35. We are on page 35.
Could you read the last 2 sentences of the first paragraph, which begins, "The division lacks clear information"?
The division lacks clear information identifying the location or locations of the sources originally bottled at the hotel. However, San Buenaventura Research Associates 2005 notes there are 25 springs on the Arrowhead Springs property that would have provided spring sources for bottled water were on the property.
Thank you. Let's go down to footnote 45 that's referenced here. It's right at the bottom of the page. Mr. Eggers, can you read that footnote?
Sorry, which footnote?
Number 45.
San Buenaventura Research Associates 2005 does not indicate that the springs would not have existed when Nestle began bottling on the hotel property.
Can you explain what that sentence means?
I believe it speaks for itself.
Help me out here. This looks like a double negative, and it would be helpful if you would explain how that footnote supports the sentence, the 2 sentences that are cited, that this cites to.
I think it means that the San Buenaventura report does not indicate that the springs didn't exist when Nestle began bottling on the hotel property.
And can we go back up to that paragraph, the first paragraph, last 2 sentences? And again, if you could simply, if you'd like, read the last sentence beginning, however.
However, San Buenaventura Research Associates notes there are 25 springs on the Arrowhead Springs property that would have provided spring sources for bottled water on the property.
So is that the consulting firm's conclusion, or is that your conclusion?
It's included in our report of investigation.
Mr. Eggers, the Footnote 45 says, because the report doesn't say that the springs didn't exist on the site, we're going to assume basically that they did exist on the site. And I'm only offering this because Mr. Eggers elected not to explain what it meant. What I'm trying to understand is whether or not the 25 springs on Arrowhead property.
That objection, one, that mischaracterizes Mr. Eggers' statement. He was asked what it meant, and he responded with what he believed it meant. Second,
All right.
the
All right.
document
I'm going
speaks for
to
itself.
sustain the objection that the question was getting too long and had characterization of testimony. Ms. McGuire, I think you can probably address this objection by restating the question with a short and to the point question.
Mr. Eggers, does the ROI conclude that the 25 springs on Arrowhead property were used as sources of bottled water?
I don't see where it says that.
Could you read that last sentence again in that last paragraph?
However, San Buenaventura Research Associates notes there are 25 springs on the Arrowhead Springs property that would have provided spring sources for bottled water on the property.
Where in the San Buenaventura Resource Associates report do they conclude that the 25 springs were a source of bottled water on the property?
I'm not sure that it says that. I believe that this sentence says, notes that there was 25 springs that would have provided spring sources.
All right, thank you, Mr. Eggers. Did you know that most of the springs on the Arrowhead Hotel property are hot springs that are filled with sulfur and other minerals, making them unsuitable for drinking?
Objection, no foundation for that. She's testifying and there's no basis given for the facts she stated.
All right, I'm going to sustain the objection. Ms. McGuire, I think you can restate that as a foundational question. Just ask him whether he or not he knows that there were hot springs on the property, and you can go from there.
All right, Mr. Eggers, do you know whether or not there are hot springs on the Arrowhead Hotel property?
I believe that there are, yes.
Could we pull up Story of Stuff exhibit number 7?
And just to clarify, is BlueTriton asking for one of the Story of Stuff exhibits rather than a prosecution team exhibit?
Mr. Petrozelli, I think for cross-examination, they're entitled to use whatever documents they want. You may be able to object to the question if you think there's a problem, but they can use any document they want on cross-examination.
There hasn't been any testimony on this yet. It hasn't.
All right. Stop. She hasn't asked a question yet. If she asks a question and you don't think there's a proper foundation, you may object at that time. But all she's done so far is ask my staff to post this exhibit. So let's let her go forward and ask a question, and then we'll take it from there.
Mr. Eggers, do you know whether this exhibit was provided to the Division of Water Rights Enforcement section by the Story of Stuff?
I haven't had time to review that exhibit.
Okay, thank you. Can we go to page 10 of the exhibit? Mr. Eggers, do you see the second bold heading, Arrowhead Bottled Water?
I see it.
Do you see the 4 subcategories of water under this heading?
I see them.
Do any of those categories of water refer to drinking water?
I don't know. I haven't had time to review this exhibit.
Please take your time.
Well, and Ms. McGuire, we don't have any foundation that he knows anything about this exhibit. So your question basically is asking him to read a document that all the rest of us can read just as well. So I think you have to establish some, I'm going to rule, you need to establish some foundation as to why it's appropriate to ask him questions about this document at this time.
Mr. Lilly, in the prior document, his testimony, he indicates that there are 25 springs on site, and he indicates that they could be the source of bottled water. I'm simply pointing out with this exhibit, that's a summary of the sources of spring water on the site, that none of them suggest their drinking water quality.
I also object that Ms. McGuire has mischaracterized a document that speaks for itself. She described 4 classes of water, and as I read this, it appears that Arrowhead water is this single class of water.
All right, let's, I think we can cut through this. First of all, the prior document was not his testimony. It was the report of investigation. It was PT3. But considering we don't have any foundation of the witness's knowledge of this exhibit, I'm just going to ask a question, Mr. Eggers, and then Ms. McGuire, you can follow up. Mr. Eggers, looking at this, the second half of page 10 of Exhibit Story of Stuff 7, does that in any way affect the previous answers you gave about the 25 springs on the property that are discussed in Exhibit PT3?
I would need to review this document for context, not just this part of it. I don't know anything about this exhibit, really.
All right, Ms. McGuire, you may proceed. I think we have a foundation problem here, but you may proceed if you think you can.
Let's go ahead.
I know you can proceed, but if you can proceed on this topic, please go ahead.
Thank you. Let's return to Exhibit PT number 3, the report of investigation issued in 2021.
All right, we have PT3, page 35 up again.
Actually, my apologies. I'm going to ask to go to PT 12, which is the PowerPoint presentation by Mr. Eggers, page 23, the very last page. There we go.
All right, we have PT 12, page 23 on the screen. Go ahead.
Thank you. Mr. Eggers, please take a moment to look at this slide. I'm particularly interested in bullet number 3.
Okay.
Is it your testimony that BTB is only entitled to 7.26 acre-feet of water in Strawberry Canyon based on its pre-1914 water rights?
Yes.
Okay. Mr. Eggers, I'm going to move to talk about rail cars. The 2021 report of investigation discusses the volumes of water that were transported in rail cars, as does your testimony. Excuse me for just a moment. Here we go. Let's go to PT 10-12.
Wait, that's that PT 10, page 12?
Yes, please.
All right. And what paragraph do you want?
I would like to go to line 26.
Scroll down.
Could you read the sentence? And it looks like it's starting at 25 and a half. It says the tank cars had a capacity.
Tank cars had a capacity of 6,500 gallons.
Mr. Eggers, do you recall the basis for the conclusion in the ROI that the tank cars had a capacity of 6,500 gallons?
Yes.
And what was the basis?
A testimony in the 1910 litigation.
Can we pull up PT 235?
I think this is a new one we've not looked at before, so it'll take us just a moment. That's fine.
PT 235.
Oh, yeah, Miss Mullen, we got PT2. We need PT 235. And incidentally, Nicole Mullen and my staff is the unsung hero behind the scenes here. I just want to let you all know what a great job she does finding all these exhibits and getting them posted. And I certainly greatly appreciate all her work in that regard. And we'll see, having made that statement, we'll see how quickly she can get PT 235, which is a new exhibit. There it is. Thank you, Ms. Mullen. And what page would you like us to go to, Ms. McGuire?
I'd like to go to page 33, please.
Okay, page 33.
All right, now this can be a little tricky because we have a wiggly page, but if you could scroll down, I think it's lines 13 through 17, yes.
Okay, so she'll make that part of the page bigger so we can read them a little better.
Mr. Eggers, can you read this page?
And Ms. Mullen, if you can make it one notch bigger for the hearing officer's old eyes, I would appreciate it. Thank you. Go ahead.
Are you able to read this page, Mr. Eggers?
We're going to start on line 13, Mr. Eggers. I believe the question is that sentence, and maybe it would help if you could read it. It begins, "It is then conveyed."
Correct. Would you like me to read it, Mr. Lilly?
Mr. Eggers, if you can read that, go ahead.
It is then conveyed from this reservoir to a large galvanized iron tank located at the terminus of the electric railway and is there turned into illegible large tank car holding approximately 6,500 gallons of water. Then conveyed to the Santa Fe and taken to the bottling works in Los Angeles.
All right, so what is your question, Ms. McGuire?
Mr. Eggers, is this statement the basis of the 2021's report of investigation that the tank cars can carry only 6,500 gallons of water?
No. I mean, that definitely is a repetition of, but I believe it was probably on page 19 of this PDF.
Okay, let's go to page 19.
Okay, we'll see if we can scroll down. Tell us, we're scrolling slowly, Mr. Eggers, so tell us when you want us to stop scrolling.
I keep going. No, keep going. I have on my notes that it was Fry A30, page 19 of the PDF of Fry A30. I'm not sure if this is the same PDF, but we can keep looking down. Keep going, keep going. Keep going. Or, yeah, it looks like it wasn't this same PDF.
Okay, well, this is page 29. I think you said page 19.
That's,
Of
Well,
the
I don't know.
PDF. Yeah.
Oh, it's PDF page 19, excuse
Yeah,
me.
I would have to review it. I'm relatively sure it was exhibit A30 of Fry, one of Fry's submissions. The file was called Arrowhead 1910 Case Part 1 Orders Minutes. And on that PDF, it was page 19. So if we can find that document.
Okay, the part
file.
1 orders minutes is exhibit PT 234. I don't know if that's what you're talking about or not.
Yeah, it probably is if that's the same file name.
So we may, Miss McGuire, do you want us to go to PT 234 and see if you can find it there?
no, Mr. Lilly, I don't think that's a good use of our time. PT
Okay.
235.
And just I'm going to just note, Mr. Petrozelli, if you want to ask Mr. Eggers this question on redirect, you certainly may. You may want to make a note of that. And Ms. McGuire, you may proceed.
Returning to page 35, I'd like to clarify, this exhibit is actually not a court ruling. It is in fact minutes, as you stated earlier, Mr. Eggers, correct? And as you can see, redirect examination on this page.
I'm not sure what you mean. Sorry.
This is testimony given in court and not a court ruling, correct?
I think that's correct.
Mr. Eggers, would you agree that the testimony of 6,500 gallons was given by the Secretary Treasurer of Arrowhead Cold Springs Company in this litigation?
I would have to refresh my memory, review this again.
Mr. Eggers, is there any other evidence that you have that supports the contention in the 2021 report of investigation that the train car's capacity was 6,500 gallons?
I believe we were trying to get there before and you declined to bring up the other document.
I believe. Let's scroll all the way to the top of this document, please.
And Ms. McGuire, I just want to say, Mr. Eggers is correct. He pointed to another exhibit, PT 234, and you said you did not want to ask him about that. So if you're going to ask him if there's other evidence, then he has pointed to another exhibit.
And I believe if we would allow.
Wait, Mr. Petrozelli, I don't.
Question, then we can pull it up.
I'm not arguing against not pulling it up.
Okay. You may proceed, Ms. McGuire, with your questions. Mr. Petrozelli, if you think you need to object to her next question, go ahead, but let's hold your comments until then.
Thank you. All right, there's no title on this page. That's where I was trying to look to determine whether or not it's the same document that we will see when we pull up 234. Perhaps we can scroll to the bottom of this 235, yes. All right, so this document was filed in Superior Court on November 17, 1910. I'd like to clarify now whether or not that is the same document as 234. Can we pull up PT 234, please?
Yes, let's pull up PT 234. Okay, this document says order at the top. We can scroll down if we need to.
Yes, could we go to page 19?
Okay, do you have a question?
I was looking for the reference to 6,500 that Mr. Eggers believes is here.
All right, let's go ahead and scroll down and see if we can find it here.
That's it.
Okay.
On page or on line 25 and 26.
I'm sorry, it's not apparent from the document. Can you just tell us what page number that's on for our notes?
Yeah, this is exhibit PT 234, page 19, lines 25 through 26.
I'll read it. The cars hold 6,500 gallons.
All right, Ms. McGuire, you may proceed with your questioning.
Just one last question, Mr. Eggers. Do you know who is this? It looks like it's referring to Exhibit H. And it looks like it's quoted statements. I was brought in. I saw it in August 1909.
And what is your question, Ms. McGuire?
Compound.
Wait. Stop. Ms. McGuire, please state a question.
Yes, thank you, Mr. Lilly. I'm trying to understand whether or not this particular page that we're seeing on the screen is part of the order or some sort of an exhibit separate and apart from the order, because I'm trying to understand the source of the 6,500.
All right. And if Mr. Eggers, if you know, you may state. If you don't know, state you don't know, and we will go from there.
I would need to refresh my memory.
All right. So, Ms. McGuire, we can all read this document. The title is Orders Minutes, and from my brief review of the first page, it looked like it was minutes of the court's order. I'm not sure it's productive to ask Mr. Eggers to interpret this document. I suspect any of the rest of us can as well as he can, but if you have some specific questions you want to ask him about this document, that's fine. You may proceed.
Mr. Lilly, I've not seen this particular document for this purpose. May I have a couple of minutes to consult with my colleagues?
Yeah, let's go ahead and do that. I realize there are a lot of new documents, and frankly, I'm seeing them for the first time too. So I'm going to say, 5-minute break. I have 10:57, 11:02. We'll go back on the record.
Thank you.
Okay, it's 11:02. I'm back. Looks like everybody else is coming back too. So let's go ahead and get started. Ms. McGuire, you've now had a chance to look at PT 234. You may proceed with your questions of Mr. Eggers. But you have to go off mute so we can hear you. We're all learning.
Yes, thank you, Mr. Eggers. Oh, Mr. Lilly, let's move on to Mr. Eggers.
And Mr. Eggers, just a warning, you're going to have to go off mute too so we can be able to hear you. Whoops. There we go. All right, now you may proceed. We're all off mute.
We're all ready. Mr. Eggers, is it your testimony that you relied upon the Exhibit 234 for the conclusion that the carrying capacity of these train cars is 6,500 gallons?
I believe that supports my conclusion, but I wouldn't say that there was one particular thing that I relied on entirely.
Okay, can you think of anything else you may have relied on as support for your conclusion?
That's the quote I think that I have in my notes, but I read all of the documents that were submitted. I tried to read all of them about the 1910 litigation. They were voluminous, and I believe that the preponderance of what's in there supports the fact that those tank cars had a capacity of 6,500 gallons.
Okay, thank you. Do you recall whether BTB or BlueTriton relied upon any information to support its calculation of the train car's carrying capacity of between 10,000 and 15,000 gallons?
I believe BlueTriton in the preliminary response to the 2017 ROI stated that the tank cars were 15,000 gallons.
Okay, thank you.
If we like, perhaps maybe we could put that portion of the response on the screen.
Absolutely.
If she wants to ask a question about it, we may. Ms. McGuire, do you want that? If you want that, please let us know.
Yes, please. Let's go to PT 149. and it would be page 11.
Okay, we're getting PT 149. And we'll go to page 11.
Thank you. Mr. Eggers, could you read the first two sentences of the second paragraph?
And I'm going to ask Ms. Mullen to make it bigger, please, so that at least I can read it. There, thank you. That's good. Thank you. Okay, and it's not really appropriate, Ms. McGuire, to ask him to read out loud a report that one of your witnesses prepared. I think it's more appropriate to ask him questions about this.
Okay.
I didn't have a problem with him reading out loud his testimony and PT exhibits, but this is a BlueTriton report, so I think it's better if you just ask him your question.
Okay, thank you. Mr. Eggers, would you take a moment to read those first two sentences to yourself, and then I'll ask you a couple of questions. Would you agree that the first sentence in that paragraph is citing to a San Bernardino Daily Sun article dated January 23rd, 1926, that rail shipments of water from Arrowhead Springs are estimated to be more than 200,000 gallons each week on an average of 3 tank cars shipped each day?
Objection, Foundation.
Object.
Wait. Let's, Ms. McGuire, I'm not, are you trying to establish a foundation? I mean, we can all read this, and asking him whether he agrees this says what it says, I'm not sure is productive. What's your purpose of asking this question?
The purpose is to establish that BlueTriton submitted evidence of a carrying capacity of the train cars that was dismissed by the Division of Water Rights Enforcement Section.
And-
Okay, so let's just split this up into short foundational questions. I think the first, I'm going to ask the first question of Mr. Eggers, and then you can go from there. Mr. Eggers, do you agree with Ms. McGuire that BlueTriton submitted evidence indicating that the tank cars had carrying capacity of 10,000 to 15,000 gallons?
I don't agree with that. You say the tank cars, but that doesn't specify which tank cars.
All right. So with that that lack of foundation, Ms. McGuire, you may proceed, but just I think it works best and will avoid objections if you just have short, succinct questions that you're asking him about this.
Mr. Lilly, I'd like to object before she starts, just on the grounds of hearsay, because this is her report. It's citing to the Daily Sun article, which I believe is in evidence because they submitted a number of articles. So perhaps it would be easier if she were to pull up the source document rather than her characterization, which is hearsay.
All right.
And
Okay,
This is
go
a
ahead,
totally
Mr.
different year.
All right. All right.
And
So-
Mr. Lilly, I was going to object on that basis as well. I mean, this is a 1926 article. We're talking about operations in roughly
All right.
1910, and there's no foundation that this 1926 article applies to that time period.
Mr.
All
Lilly,
right.
we're going out into attorneys testifying again. Hearsay.
All
is
right. Everybody stop. I've heard enough. I'm going to overrule the objections. I'm going to allow Ms. McGuire to ask this witness if, number one, first of all, what information, I don't know whether we'll call it evidence, but what information or documents on this topic the Division of Water Rights Enforcement Section received from BlueTriton and what the Division of Water Rights Enforcement section did with that information. I think that will cut through this. So Ms. McGuire, you may proceed.
Thank you. Mr. Eggers, do you recall what information BlueTriton submitted to you as evidence of the carrying capacity of the rail cars?
This assertion that we see here on this page.
Do you recall any other sources of evidence of the carrying capacity of these train cars?
Could you be more specific about which train cars?
Train cars that carry water. The same train cars that were cited earlier in exhibits 234 and 235.
Wait. Now I've got to sustain the prior objection. There's nothing that says that these are the same train cars. These are train cars that apparently were discussed in a 1926 article. If you're going to assert in your question that they're the same train cars, I think you have to establish a foundation for that.
Let's go to exhibit 5 of this document.
Could you have a page number within this exhibit?
Page 48.
Okay. It's just easier for us to scroll to pages, as you can see. All right, so here we are on page 48 of exhibit PT 149. You may ask your question.
Could we scroll down just a bit further? Mr. Eggers, can you, at the bottom of this page, there will be a date. And so I just want to scroll down.
Whoops, there we go. I see a date at the bottom, LA Times, May 21, 1906. So what, Mr. McGuire, what is your question for Mr. Eggers?
Mr. Eggers, do you recognize this as a train car, the photograph at the top of the page that we provided?
Objection, because it appears that the LA Times is not part of either of the other things. It looks like things have been pasted on top here. Also, no foundation has been laid as to where this came from, and if it is in fact a compilation as opposed to a single article.
Okay, I'm going to overrule the objection. The question is simply, if Ms. Mullen, please scroll to the top of the page. The question is simply, does Mr. Eggers recognize this as a train car?
Correct.
That appears to be a train car.
All right.
Okay.
Mr. Eggers, I'm going to move on to exhibit PT-10.
All right, let's put up PT-10. I think we've had that before. PT-10 is Mr. Eggers' testimony. We're back to that. Go ahead.
Page 14, please, paragraph 41.
Okay, what is your question about this paragraph?
Mr. Eggers, is it your testimony that you could not confirm that the old Arrowhead factory was built prior to 1914?
Could you point out in my testimony where I say that?
Let's start on line 7 with newspaper articles published at that time.
Newspaper articles published at the time corroborate the respondent's assertion that AHSC built a bottling plant near the hotel before 1914, but not the specific timing.
Could you also then read the following sentence beginning with furthermore?
Furthermore, even if the old Arrowhead factory was built on non-riparian land, available information does not support a reasonable inference that the factory would have expanded the respondent's right beyond 7.26 acre-feet per year.
Mr. Eggers, could you explain why that there's no possibility of a reasonable inference that the factory could have been expanded beyond 7.26 acre feet?
I didn't say that.
Mr. Eggers, your statement on line 10, available information does not support a reasonable inference that the factory would have expanded the respondent's right beyond 7.26 acre feet. Is that correct?
That's correct.
Okay. Can you
That's
explain?
not what you asked.
Yeah, Ms. McGuire, that your question before was different, but go ahead now based on what he said here, or what his testimony states here, I should say.
Mr. Eggers, could you please explain to me the reasons why you cannot make a reasonable inference that the factory would have expanded?
And I'm going to, I think there's a little confusion here, Mr. McGuire. I don't know whether it's intentional or not, but there's a difference between whether he can make whether an inference can be made or whether available information is there. And I think that's the hang up Mr. Eggers is having. So Mr. Eggers, please explain why available information does not support a reasonable inference that the factory would have expanded beyond 7.26 acre feet per year.
That's not a correct characterization of that sentence. It says whether the factory would have expanded the respondent's right.
Okay, so maybe you could just explain it. And if I'm getting mixed up too, I apologize. Just explain the basis for that clause that begins with available information.
There seems to be a misunderstanding where she thinks that I was saying that the factory couldn't have expanded, and its use of water at the factory wouldn't have expanded the right beyond 7.26 acre feet.
Okay, I do appreciate the distinction between the factory and the right. Ms. McGuire, you may proceed with your questions, but obviously this is an important distinction, so please be careful with your questions. And I apologize, Mr. Eggers, if I was not careful with my question. But go ahead, Ms. McGuire.
Mr. Eggers, could you please explain why the use of water at the factory could not have expanded beyond 7.26 acre feet?
The material object.
Also asked and answered, and he's clarified.
No. The objections are overruled. We're trying to get this clarified. I'm not sure that that's exactly what that statement says, but please go ahead. Mr. Eggers, can you answer that, or do you want her to repeat that question?
There was some question about whether the use of water was sufficient to perfect the incipient right created by the 1909 contract for 7.26 acre feet per year. And if that Arrowhead factory was not able to use up to 7.26 acre feet per year, then it would not have perfected that incipient right entirely.
All right, Ms. McGuire, you may proceed.
Mr. Eggers, on what basis did you determine that the old Arrowhead factory could not have produced more than 7.26 acre feet?
The old Arrowhead factory, was a small factory. In the preliminary, I believe it was a preliminary response to the 2017 report of investigation, BTB estimated that the factory produced, I believe, less than 6 acre feet of bottled water.
Mr. Eggers, if you could read line 6 of your of this page. I think that will answer your statement.
The respondent estimated that the old Arrowhead factory would have used 9.5 acre-feet per year for manufacturing operations.
Thank you. Mr. Eggers, are you aware of a third-party contract entered into by Arrowhead Hot Springs Hotel in 1909?
I'm aware of the 1909 contract.
And do you recall the volume of water that you believe was shipped under that contract?
No, I don't think we made a conclusion about that.
Mr. Eggers, do you agree that the 1909 contract would have resulted in the sale of bottled water prior to December 1914?
Yes, that's my conclusion.
And would you agree that the old Arrowhead factory was in existence prior to 1914?
Yes.
Thank you. I'd like to have 5 minutes to consult with my colleagues before I finish the testimony, if I might, Mr. Lilly.
All right, that's fine. And again, I am trying to keep our clock ticking here, so we'll come back at 11:27.
Thank you.
All right, it's 11:27. Looks like Mr. Eggers is back. Ms. McGuire is back. We've got to get Mr. Petrozelli. There's Mr. Petrozelli. All right, everybody else is starting to reappear. Ms. McGuire, you may proceed.
Thank you, Mr. Lilly. I'd like to ask just a few more cleanup questions, and then we can finish with Mr. Eggers' cross-examination.
All right, please proceed.
All right, I'd like to go back to our earlier discussion about the conclusions reached in the 2021 ROI. And specifically, and I'm not sure that I asked this question, and I want to get your response to it, which is, after August 2018, did you receive any information that changed the conclusions that were reached in the 2021 report of investigation?
I might have to think about that for a bit and invite any of the other panel witnesses to also chime in.
All right, yeah, Ms. McGuire, I understand, there's a question whether it's relevant or not, but I understand why you're asking the question. But in fairness to Mr. Eggers, you are asking him to recall work over 2.5 years, and some of it by his colleagues as well. So it's sort of a tough question to answer, particularly without his going back and reviewing his notes. So I think he's answered it as well as he can, but you may follow up if you think it's appropriate.
Well, let me just make sure that I ask the question properly. Mr. Eggers.
And just so we're clear, I wasn't suggesting that your question was improper. I'm just saying it's hard for him to answer.
Right. I was going to narrow the question if I hadn't done it originally, which is to simply ask him if he recalls whether any of the conclusions in the 2021 ROI were changed as a result of receiving information after August 2018.
What do you mean by conclusions? Do you mean specifically that portion of the report, or any determinations or interpretations that we made? I don't know. That's
A number of conclusions are reached in the 2021 report of investigation. I'm asking if you recall whether any of them changed after August 18 or August 2018. In other words, did information you received after that time change any of the conclusions in the 2021 ROI?
I would have to think about that more.
Okay, we will move on. Mr. Eggers, did you review and consider the information BTB submitted to the enforcement team following the issuance of the 2017 ROI and before the issuance of the 2021 ROI?
We reviewed all the information that was submitted, to my knowledge.
Okay. Did the enforcement team have a hydrologist review the information that BTB submitted in responses 2, 3, and 4 pursuant to the 2017 ROI's direction?
Bring up those exhibits.
Those are, I know they're BTB exhibits 3, 4, and 5.
We'll go ahead and put them up. Just Ms. Mullen, please put up BTB 3. I think probably the first page of each one will help refresh Mr. Eggers' recollection on what those are. While she's getting those, Mr. Eggers, I may be able to help. BTB3 is, oh, here we are, the March 12, 2018 letter from Ms. McGuire. BTB4 is the April 10, 2018 letter from Ms. McGuire. And BTB5 is the June 20th, 2019 letter from Ms. McGuire. So I think the question that she asked is, did the Division of Water Rights Enforcement team ask a hydrologist to review any of those three exhibits?
No, I'm not sure if anybody who reviewed it has qualifications as a hydrologist.
Do you know if the Division of Water Rights Enforcement section had a hydrogeologist review any of these reports?
You know, I'm not familiar with everybody who reviewed the report's qualifications.
Let me ask you whether a geologist may have reviewed it, if you recall.
Again, I'm not familiar with everybody who reviewed that's qualifications.
Okay. Can you tell me who on the enforcement team reviewed the 2021 report of investigation before its issuance?
I don't know everybody who reviewed that.
Okay, thank you. Mr. Eggers, did you rely on any notes for your testimony?
For my testimony is in written form, so.
The testimony that you provided here today under cross-examination, did you rely on any notes for that testimony?
I have notes.
Wait. I think this is important distinction. And this is a little tricky because we're doing this all remotely. That Mr. Eggers, did you refer to any notes yesterday or today while you were giving your testimony?
I have notes that that help me identify things that I needed to remember.
Okay, Ms. McGuire, you may proceed.
Mr. Eggers, would you please preserve those notes?
And Mr. Eggers, you should, in fact, she can't tell you what to do, but I can tell you what to do. So please do preserve those notes, because it is appropriate, if the BlueTriton attorneys decide they want to ask you to produce any notes that you actually looked at while giving your testimony today and tomorrow. That's distinct from notes you may have used to prepare your written testimony, which they don't normally have a right to. But if you had notes that you used yesterday or today to help you answer your questions, they are entitled to see those. So please do preserve those.
Mr. Eggers, did you?
Excuse me, Mr. Eggers, can you just say, yes, I will, or something like that, please?
Yeah, I understand.
All right, thank you.
Thank you, Mr. Eggers. Did you receive any emails or text messages during the course of your testimony today and that assisted you in your testifying?
No.
Okay, all right, Mr. Eggers. Did any other documentation get used by you to assist you in responding to these questions during the course of your testimony?
The other documentation, I'm not sure I understand that question.
Any other documents, letters, correspondence, emails, texts, notes, anything that we haven't covered?
The only thing that I used was my personal notes and the documents that were up on the screen.
Okay, thank you very much, Mr. Eggers. That concludes my cross-examination.
Right, thank you, Mr. Eggers, and thank you, Ms. McGuire. Let's talk about how we're going to proceed. I think we'll probably take a little bit of an early break today because we're at a good point for a break. First of all, by raise of electronic hands, if you can or if you can't, real hands, who wants to ask Mr. Vasquez or Mr. Eggers questions at this time? These will nominally be cross-examination, although they may be what we will call more in the nature of direct. So I have Ms. Doty. Hang on, keep your hands up, please. Ms. Fry, Ms. Nickel, Mr. Lowe. I have those four. Anybody else? Doty?
Will Ms. Stork also be available?
Oh, yes. Okay, yes. Thank you, Ms. Doty. So I have those four people, looks like two attorneys and two interested parties who wish to ask questions. First of all, I'm going to say something which may affect your answer. And the attorneys should know this, but I'll say it for everyone. The prosecution team witnesses, the prosecution team is probably not an adverse party to any of the other parties who are wanting to ask questions. I don't think. Potentially Ms. Nickel may argue with me about that, and we will see. But I think for everyone else, definitely the parties are aligned with the prosecution team. And that means you are not allowed to ask leading questions. Questions that suggest the answer. You need to ask basically open-ended, non-leading questions. And that's probably a good idea anyway. And I, particularly for those of you who are not attorneys, I want to admonish you, there can be a tendency to try to say a lot of things and then may or may not have a question at the end of a long statement. And that is not appropriate. I want short, to the point questions, no statements. Those of you who are testifying will have a chance to testify later on. So that is number one admonishment, or the only admonishment. So, and Mr. Petrozelli, do you have something we have to talk about now, or can I first figure out who's going to ask questions?
This can wait until you're done with this portion. I just want to be sure you get to me.
I will get to you before our break. Thank you. All right. So with that, I would like to get rough time estimates, and I fully understand that depending on objections and answers, you may not be able to get exactly the right amount. But Ms. Doty, how long do you think your questioning of these three witnesses will take?
I'm looking at 15 to 20 minutes, but I would ask for the courtesy of going after Mr. Lowe and Ms. Fry, please.
Okay. And Ms. Nickel, how long do you think your questions will take?
I expect only about 5 minutes.
All right. And Mr. Lowe, how long will your questions take? Please go off mute. There we go.
Maybe 15.
Okay, 15. And Ms. Fry, how long do you think your questions will take?
5 to 15.
5 to 15. All right. Well, that's good. That's means we should be able to wrap up this afternoon easily. And then I probably have, now you're going to all try to hold me to time limits, but I probably have 5 to 10 minutes of questions max. And then Mr. Petrozelli, you certainly are going to have a right to redirect. You have an estimate for your redirect.
It's hard to say at this point until we see what all of the cross-examination is. Right
I
now,
understand.
I don't think a whole lot, but we have to talk. We'll have to talk about it more.
Okay, well, I mean, you've heard all the cross-examination for BlueTriton, which should give you a pretty good idea. I mean, do you think it's more than half an hour?
Oh, no.
Okay, I'm going to put less than 30 minutes. And by oh no, I will take it to mean maybe substantially less than 30 minutes.
Yeah.
But we'll go from there.
Yeah,
All right.
I don't want to commit us to anything yet.
All right. Is there something else? Well, so let me just tell you my plan. I think it would help you all to have a little time to organize your questions, go over them. I'm sure most of you have prepared them ahead of time, but I'm going to break until 1 o'clock. So I'll give you that time and then we'll proceed with questions. And in response to Ms. Doty's request, we'll have the order be, let's have Ms. Nickel go first, and then Ms. Fry, and then Mr. Lowe, and then Ms. Doty, and then me, and then Mr. Petrozelli, and then we'll see whether there's any need for recross by the BlueTriton attorneys after that. So we'll start at 1 o'clock with that. If you have any exhibits, please make sure you have the numbers ready so that we can get them up on the screen promptly. And we'll go forward. And just one other reminder, when we do log off, make sure to log off this time because you have to re-log on because we do a whole separate recording for the afternoon. So Ms. Belenky, do you want to say something? Your real hand is up.
Yes, my real hand.
We
I
still
had a
have those.
quick question because yesterday morning you said you were considering taking off Wednesday, but given how little we've gotten through in the first day and a half, I'm wondering if you've reconsidered that.
Okay. What I was planning to do, you anticipated my next comment, but that's fine. I had said yesterday, and I think we'll still do this, that after we're done with the cross-ex and redirect and so forth, questioning of the prosecution team's witnesses, we will proceed with BlueTriton's witness. Mr. Lawrence is the only witness they have designated. And we will start that this afternoon, or if we can. I do have to leave about 3:30, so I don't know whether we'll finish that or not. But we'll start with that and see if we can finish it. And then maybe we should talk about it now. If we don't finish that, I definitely want to do that Wednesday morning to wrap that up. I was then planning to have a break until Thursday to give particularly BlueTriton, but the other parties as well, a chance to go through the other parties' exhibits, particularly Ms. Fry and Story of the Stuff Project had very lengthy exhibits, and we've had limited time to look at those. So that is my tentative plan. Does anybody have any comments on that? And Mr. Lowe, your hand is up. Do you have a comment on that?
I just wanted you to know that I have family obligations tomorrow afternoon, so I can't really be involved tomorrow afternoon.
Okay, well, that would be consistent with our taking tomorrow afternoon off.
Yes.
All right. Anybody else have any questions, comments, or issues regarding timing? All right. So let's do that. And BlueTriton, you are on notice that sounds very formal, but just to let you know, it looks like we will be able to get to Mr. Lawrence's testimony this afternoon. And I would like to do that if we can, to use the time, and then we'll see how far we get with that. My tentative plan then would be to take a break on Wednesday, but we can revisit that this afternoon. So is there anything else anyone would like to discuss before we take our break? Oh, wait, I have a hand up. Mr. Petrozelli, go ahead.
Yes, you previously asked for Ms. Dork's statement of qualifications. During the break, I would like to follow up with her and see if we have something that is ready to submit. If not, I can perhaps give you an update as to when we.
All right, please give me an update. And if I forget, you can remind me.
Okay.
When we reconvene at 1, if you can upload it, just go ahead and label it PT311, I think is your next number.
That should be next.
And you can upload it. And if you can just send an email to the AHO. Well, no, you don't have to send an email because then you have to CC everybody and that's a pain. But if you can upload it, please do. And we will check and move it over to the PT exhibit folder so everyone can see that if you do. And if it takes more time, that's fine. But if you can get it, that would be good.
Yeah.
All right. Thank you. So I don't see any more hands, electronic or real. So we will take a break until 1 p.m. We will start promptly at 1 p.m. this afternoon. Thank you all.